All right, teachers. So today we're going to talk about student rights in non-instructional matters. So first we have to talk about the First Amendment. And the First Amendment says that Congress shall make no law respecting an establishment of freedom or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. So in my first PowerPoint to you guys, I talked about prayer and religion. So now we're going to talk about things that are non-instructional, basically free expression. So free expression rights are the most preciously guarded individual liberties and are relied on to protect unpopular viewpoints. So people use the freedom of expression when somebody does something that they don't like. So let's talk about those different kinds of expression. So expression that is obscene, lewd, and vulgar. The First Amendment right does not cover the right to voice these obscenities. Schools don't have to prove that expression is obscene for it to be curtailed. And the most important case that we have that went to the Supreme Court is Bethel School District versus Frazier in 1986. And basically, at a school assembly in a high school, Matthew Frazier makes a speech and he's nominating a fellow student for office. In his speech, he uses what some observers believe was graphic sexual metaphors to promote the election of his friend. If you want to see exactly what those metaphors are, you can search it on Google. Bethel High School enforced a rule prohibiting conduct which interfered with the educational process. And Frazier was suspended for those 2 days. So what did he do wrong? What he did wrong was that his expression was obscene, lewd, and vulgar. He didn't have just a regular speech telling everyone they should vote for him because he was a quality man. He spoke about things in a graphic sexual way. So the Supreme Court held up that lewd, vulgar, indecent student speech is not protected by the First Amendment and does not have to be disruptive to be banned. Now, everybody that was at this school assembly heard what Matthew Frazier had to say. How they felt about it, we don't know, but it wasn't enough for him to get in trouble. So, and this gave the idea that school authorities can determine what expression is lewd and what expression is vulgar. So while students do have free expression, they don't have expression to be lewd, vulgar, or indecent. So let's talk about school-sponsored expression, because that's a little bit different. So the first thing we have with school-sponsored expression is a public forum. So to give you a little bit of background on public forums are traditional places for people to assemble and communicate. In a public area, people can assemble and communicate. So the government can create a limited public forum for expression on public property that otherwise would be a non-public forum. So a student activities program held after school might be established for this student expression on a certain topic, on Jesus Christ, on homosexuality, on abstinence till marriage. Lots of topics, lots of issues. Now, if a school allows one type of a limited public forum, they must allow other types of limited public forum as well. So, if the high school decides that they are going to allow a Christian group to meet and pray and discuss religion and talk about the Bible, then they also have to let a group of Wiccans that want to talk about their Wiccan belief after school, they have to let them as well. Now, under the Equal Access Act, if a school establishes a limited forum for student-initiated clubs to meet during non-instructional times, that's after school, that's definitely not during the 8 to 3 normal school hours. It has to be after school. The policy must be for all. Like I said, with the Wiccans, they're allowed to come too. The Satanists, the people that want to, slaughter animals. However, schools are not required to create a forum at all. So a high school can say, no Christian group you can't meet because we don't let the pregnancy group meet. We don't let the abstinence group meet. We don't let the KKK meet. So if we let nobody meet, they do not have to create the forum, which is just part of the student expression. So that leads us to Hazelwood School District in 1988 versus Kohlmeyer. So students wrote school newspaper articles, and they were about divorce and teenage pregnancy. The principal did not want to let the pages with those articles be distributed for fear that the specific individuals they were talking about that were pregnant or going to be pregnant or were divorced could be identified, and potentially there'd be a liability. So the Supreme Court upheld the school authorities for censoring the articles. You say, well, that's the student expression. Yes, it is, but Hazelwood School District versus Kohlmeyer held that public schools can regulate student expression that represents the school as long as the decisions are based on legitimate pedagogical reasons. So whoever the principal was at this school, he decided that those newspaper articles were going to cause issues for his school. We're going to cause liability for the people in the stories, and that it was going to cause legitimate pedagogical concerns for him and his school. So that brings us to Tinker versus Des Moines Independent School District. So in this actual case, 3 students were suspended for wearing these black armbands to school. They thought they would just do it to show their expression. Excuse me. The school made a policy forbidding the wearing of armbands. And the school officials did not prohibit students from wearing all symbols. So they didn't say, we're going to say no symbols are allowed here in Des Moines. We're just going to say that students cannot wear armbands. So the court declared that the school must have more than a mere desire to avoid the discomfort of this expression. So they can't say, oh, we don't like that because you might be representing something we don't believe in. It has to cause a problem. Students are persons under the Constitution, and so they are given the right to free expression. So students may express opinions on controversial topics as long as the exercise of these rights do not pose a substantial disruption of the educational process or impinge on the rights of other students. So this is very important to understand. Students can express themselves pretty much in any way they want as long as there are 2 things that don't happen. You can't disrupt the educational process, so it can't disrupt school, it can't disrupt academic class, it can't disrupt a school event, and it can't impinge on the rights of other students. So a student can't do something that's going to cause the rights of somebody else to be disrupted. So now I have some cases that I want you to read each one. And I want you to think about what we talked about with Tinker and Des Moines and Hazelwood, and see if you can figure out, is this allowed? And if it's not allowed, why? So the best way to do is just pause this video, read the first one, think about it, maybe jot some notes down, come back, I'll give you the answer, or what I think is the answer, and then we'll move along. So, the first one says, a group of students boycotts a student's suspension by setting up a table in the hallway in front of the 6th grade lockers and asking their peers to sign a petition. So pause and think. Okay, so for number 1, the courts say that walkouts, boycotts, sit-ins, and other protests that block hallways, damage property, or cause students to miss class result in disciplinary action. So what they're doing, even though they're being expressive, they're expressing themselves in a manner while people cannot get through, they're blocking the hallways, and that is causing a disruption of the learning environment. Okay, read number 2, pause it, and think about it. Okay, 4 football players sign a petition to get their head coach fired. So, the petition disrupts the team, and the boycott disrupts a school activity. So the football players can't play football because they're disrupting the environment of what is going on. So that is also, they would also be, there would be disciplinary action for that group. Okay, take a look at the third one. Students come to school wearing buttons that say F school. And it actually, says it all out. So this is vulgar, lewd, obscene, or offensive, but it's a button. So it can be banned if it's considered private expression. So if we say, okay, that button that you're wearing is your own private expression, we have to ban it. Kind of like Matthew Frazier and his discussion of his classmate. All right, I got a couple more for you. So a group of boys creates a magazine at home about their teacher and peers. They sell this magazine in a local store and don't bring it to school, but they tell their peers where they can purchase it. So this one's interesting because it can't be disciplinary action because the school can't prove that the magazine had an adverse effect on what's happening in the school. So there's no way the school can say, this magazine is why that student got in a fight. There's no way to connect them. So no disciplinary action is taken. Okay, take a look at the second one. All right, a student wears a shirt degrading homosexuality at school. So his shirt collides with the rights of other students. So we talked about how Tinker has the two parts. Does it mess with the learning environment? And does it mess with someone else's rights? So by wearing that shirt about homosexuality, that person is colliding with the rights of another student. And it could create a disruption of the educational process. There could be an issue that occurs because of that shirt. Thus, that shirt would be not just free expression, but it would take the rights of another student away from them. So disciplinary action would need to occur. All right, last one. So a student posts on Twitter that he's going to shoot 3 people at school tomorrow, and he lists their names. So this is not free expression. This is a threat, and it must be taken seriously. So disciplinary action would need to occur for this student. So in conclusion, there's important things to remember, kind of like your cheat sheet here, to help you understand the rights that students have. So students do not have a First Amendment right to engage in expression that is defamatory, obscene, or lewd, or that promotes illegal activity. So that goes back to our school shooting a few minutes ago we talked about. Student expression that represents the school is subject to restrictions. Excuse me. Student-initiated expression of ideological views cannot be curtailed unless the material interference causes a disruption of the educational process. That's a key information that you need to learn. And school officials cannot punish students for the content of materials that is published and distributed off grounds. So, the book I got all this from is Public School Law, and it is an amazing book, and you should add it to your collection because it really answers lots and lots of questions about the law. Okay, thank you.